Best patent attorney, Silicon Valley, California. Call 408-890-6549.
Welcome to Patent Pod Chat with noted inventor and patent attorney Chris Maiorana. Each week, Chris answers your questions on patents, trademarks, and inventions. Now, here's Chris Maiorana.
We did some interviews discussing the overall process when filing a patent application, and I remember one that discussed the details of maintenance fees, and then another that discussed a notice of allowance. Are there any other types of office actions that get sent?
Yes, there are. Sometimes we overlook some of the not really easier transactions, but smaller transactions. And one important transaction the Patent Office mails is called an advisory action.
Well, that sounds kind of funny. And an advisory action is that the same as an office action? I mean, I wonder why do they use the word advisory?
Yeah, it does sound a little bit weird. And back when we discussed the final office action, we had an interview on that. I mentioned that the Patent Office doesn't necessarily need to consider remarks and amendments that are made after the mailing of a final office action. So they use the word final to basically keep track of the examiner's counts. And if you remember, the counts are how the examiner gets paid. It's sort of, in a way, they're on a commission. It's not so much a commission as they have to get so many counts per pay period, and they get that based on mailing a first action and mailing a potential final office action. So the advisory action normally explains why the examiner is not entering the amendment that was presented. So they're advising us on the Patent Office's unwillingness to enter our previous amendment.
The examiner has a choice whether to enter an amendment or not?
He has a choice when it's a final office action that's pending. So if the office action is non-final, the examiner does need to enter the amendment because the applicant has the right to amend one time.
Okay, wait a minute. You say you can only amend one time, but we discuss an amendment after final. And this is all pretty confusing. There must be a catch, right?
There's always a catch with the Patent Office. So on an after final office action or amendment, the Patent Office does not have to enter the amendment, but they will enter the amendment if we pay a fee for what's called a request for continued examination, or RCE.
Okay, I see. So you basically pay the Patent Office for another bite at the apple, is that correct?
You're getting pretty good at this, Steve. We use the second bite at the apple as an analogy all the time. So we like to avoid an RCE if we can, but sometimes it's necessary because you get to the point where you either have to amend the claims a second time or you need to go to an appeal. And we did a whole interview on the appeal process. That's expensive. We need to make sure everything's in 100% order. So we need to balance the cost of paying the Patent Office to review a second amendment or move to the appeal process. So that's one of the balances that we make.
Thank you for listening to Patent Pod Chat with noted inventor and patent attorney Chris Maiorana. Join us next time as Chris answers your questions on patents, trademarks, and inventions.